it had been abandoned?
I think I have. I think they must have got caught in the queue, so I'm sorry on their behalf.
Well, do you? I don't want to embarrass them, but yes, here they come. Right, we'll just wait. Do have a seat.
Thank you.
Good.
They missed the bit where I said Mr. West is now going to do the remainder of the submission. My lords, my lady, before lunch we were on trusts. I just want to take you back, please, to the judgment below. And can I just show you, can we go please to Core Bundle 1, tab 10, page 114. So I'd just like to show you what the judge was shown and what he looked at, and you can see our submission that they're recorded in paragraph 19, being that the English law of trusts, under the English law of trusts, it's the trustee who has title to sue in respect of a tort which damages the trust property. We referred to a judgment there of Mr. Justice Murray. At that point he was sitting as a Deputy High Court judge, but he set out the case law and the general principles, and you can see that he set out part of Lewin on trusts, and you see there, if I can just ask you to read 17 and 18, the excerpt there.
Yes.
And then we also took him to, if you look on over the next page, page 115.
Oh, there's Chaplain Summers, yes.
To Chaplain Summers. And the reason why we've put Webster in the bundle now is not because it says anything different, but it's a more recent authority, but it's really authority for the same proposition. So the judge accepted the general rule, and we saw that, I showed you that at, I think it was paragraph 57 on page 123 of the judgment. But he said that where there's a separate duty owed to the beneficiary can also have title to sue. And we accept in principle that if a separate duty is owed to the beneficiary and the beneficiary has suffered a loss, then the beneficiary will be able to sue. Now here, but we say that there's no separate duty owed to the beneficiary in this case, which brings us back to the Article 101 point, which I'm going to deal with in due course. The judge relied, you can see at paragraph 57, on Yacht. Can I just show you what we say about Yacht in our skeleton?
Could I just ask you about something you just said a moment ago about accepting that a beneficiary can sue if a separate duty is owed?
Yes.
Does the word separate mean anything?
A distinct duty for loss which is regarded as distinct in law. And so what we say, we say that the judge's error here, in a nutshell, and this is the reason why I took you to Young and Murphy, is that the loss which is alleged to have been suffered by the beneficiaries in this case, which is said to give rise to the separate cause of action, the loss is in the form of reduced redemption monies. When they withdrew their interest, when they redeemed their interest in the trusts. And we say that that wouldn't be regarded as a separate loss to the trust property.
No, we're moving between issues of loss and duty. That's what I'm trying at the moment
I see.
To understand.
Yes.
Are you saying that in a case where there is a trust and damage is caused to the trust, there is no duty to the beneficiaries?
We're saying that where there is damage caused to trust property by a tortfeasor, there is no separate duty to the beneficiary.
Well, you keep using the word separate. What's it add?
Well, there is no duty owed to the beneficiary. So
and that's what it means, isn't it?
Well,
what you're saying.
There's
no duty owed to the beneficiary arising out of the damage to the trust property.
Yes, so there's no duty to the beneficiary arising out of damage to the trust property. That's a more
So
accurate
I'm just
formulation.
wondering why we worry about separate and distinct and words like that. I mean, if your submission is right, there isn't a duty.
That's correct.
Is that what it amounts to?
That's yes. My lord, yes, that's right. So we say that there is no duty owed to the beneficiary. The separate and distinct point relates to the loss, because what's being said by the banks is that there is a separate duty that's owed to the beneficiaries, because the loss that they suffer when they redeem their investment is distinct.
So the fact, you're saying that the fact that they may have suffered a loss can't be reverse engineered to create a duty.
That's right. So it's because it's not a separate loss. So if there were a distinct loss that were suffered, that would be one thing, but this is not...
Arising out of the breach of some other sort of a duty.
Exactly.
Right, I'm only concerned about what the particular words mean, because they all acquire a sort of term of art.
My lord, no, that's a very fair
Capacity.
observation. So to be clear, we say that where damage is caused as a result of a tort to trust property, there is no separate duty. There's no separate cause of action that arises on the part of the beneficiary. And what's said against us is, well, here, the loss that the beneficiary suffers, so it's accepted, the judge accepted, and we understand the banks to accept, that while the beneficiary is a current beneficiary, that position holds true. But what's being said is that when the beneficiary redeems their investment, then at that stage, the beneficiary acquires a cause of action, because a separate and distinct loss is caused to the beneficiary at that stage, because they receive less money.
You say that the later realisation of the amounts cannot give birth to a duty which didn't exist beforehand.
That's exactly what we say, and so we rely again, as we have before, on the Elliott and Hatton's case in terms of the principle, which is the initial loss to the trust property. And if the beneficiary then redeems its investment and the investment is worth less, that's still the same loss. It's still damage to the trust property. It's being realised at that stage in the form of a reduced payment. So it's analogous to the position for companies. And I just want to show you two passages in the respective skeleton arguments. So if we can go to Core Bundle tab 5, page 49, this is our main skeleton argument. So the banks relied, and the judge placed weight on the Yacht case, as you've seen in the judgment. I think it's paragraph 72.
What page do you want us to go to in the skeleton argument?
Page 49 of the bundle, internal page 16 of the skeleton argument. And this sets out our response to the Yacht case. So we say that in Yacht, that the beneficiaries were caused to expend substantial sums themselves. And so there was a separate and distinct loss, which, by reference to which there was a separate cause of action on the part of the beneficiary. So that's part of how the judgment is dealt with. But then you see our footnote, because we can see that Mr. Justice Ferris went further. He said that a solicitor, this is footnote 17, please, at the bottom of the page, a solicitor that agrees to act for trustees must be regarded as owing to the beneficiaries the same duties of care.
I mean, it's a matter of professional negligence law, that's just wrong.
We just say it's wrong.
Just wrong.
Yes, exactly.
Well, you've got the other authorities there, but I mean, it goes back to the point that my lord was exploring, which is you can have the scope of the duty may be the same, but when you talk separate, so between trust and beneficiary, if a duty is owed, but it would have to be a separate duty for a separate loss.
My lady, precisely, and that's why here in the main point, or the main point in Yacht, we say, is that the beneficiaries were caused by the solicitor's negligence to spend money themselves over and above the damage caused to the trust. And so that was separate. And insofar as Mr. Justice Ferris went further, we say that's inconsistent with the cases that I showed you. And what's being said in this case, of course, is, well, Article 101 provides this separate duty, and I'm going to come on to say why it doesn't. Can I just show you also behind tab 6, page 81 of the bundle, this is the bank's main skeleton argument. So paragraph 51. So they're addressing there our point that the redemption of the interest doesn't generate a new loss, and they say, this is the second part of the paragraph, a general interest in a pool of changeable trust assets is clearly different in nature from a personal interest in a specific sum of money in the form of the redemption proceeds. Where such redemption proceeds are lower than they would have been absent the infringement, the redeeming beneficiary suffers a specific loss personal to it. And we say that it's right, of course, that a general interest in the trust assets is different in nature to an interest in a specific sum of money, but it doesn't follow that that gives rise to a separate loss. So it really comes back to the same point that the Court of Appeal of Victoria looked at in Young and Murphy, and also with the principles in Elliott and Hatton.
I mean,
so,
the loss in Yurt had nothing to do with trust property. It had to do with additional expenses.
But that's how we see it, yes. But the judge, I think, went further in his reasoning, further than he needed to go, and we say to that extent he was wrong. So in summary on trusts, we say that the distinction drawn by the judge and by the banks between current and former beneficiaries is unprincipled and unworkable, and that the general rule in trusts law applies. And as I say, I'm going to come on to show why Article 101 doesn't change that, doesn't require the court to adopt a different approach to the general approach laid down by English law. So that's trusts. I was going to then turn to limited partnerships, which I can deal with very swiftly because it follows the same scheme, as it were. So it's really the same point, but in the partnership context. There are only a very small number of appellants that take the form of limited partnerships. And if we can stay in, please, the respondent's skeleton argument and turn to page 83. We see at paragraph 57 that they say that there's a certain amount of common ground between the parties in relation to limited partnerships. So first of all, there's an established distinction between claims vested in a partnership, in other words, in the body of partners as a whole, and claims vested in individual partners. And then secondly, a claim which is a partnership asset cannot be prosecuted by a limited partner. So that's common ground. And then they make the further point of paragraph 58, which has also always been common ground between us. And for your reference, we make the same point at paragraph 58, subparagraph 4 of our main skeleton argument. We don't need to turn it up. But the point is that a limited partner may bring a derivative claim in the name of the limited partnership, but if they do so, they lose the benefit of their limited liability, because doing so would constitute involvement in the partnership's management in accordance with section 6.1 of the Limited Partnerships Act 1907. So again, what's in para 58 is a matter of common ground between the parties. And then turning over the page to page 84, it said that the issue between the parties is our argument that the only exception to that is a derivative claim brought by a limited partner standing in the place of the general partner. This is incorrect. A claim may be brought by an individual partner in respect of a duty owed to it personally, and then the certain limited partners in Henderson Fund case is referred to, and it said that in short 20 limited partners brought a claim against inter alia the general partner, alleging he had used the partnership's capital to make unauthorised investments, and Mr. Justice Cook found that each limited partner had his own contractual or fiduciary claim for its own loss. And we accept, as I've said, that if a duty is owed to an individual partner personally, they can bring a claim, and this appears to be an example of such a case, because it's a claim by individual partners against the general partner for misuse of funds. And then, so the crux of the dispute between the parties is what we see in paragraphs 60 and 61 of their skeleton argument. And you see at 60, similarly to the law of trusts, there's a distinction between the interests of an existing and a retiring partner. And you see at B, in relation to retiring partners, their share may be viewed solely in financial terms. That's echoing the point I just took you to in their skeleton in relation to trusts. And then we see, in the present case, this is paragraph 61 on page 85. So as the judge found, a duty is owed to the respondents under Article 101, as I say, I'm coming to that. B, if a limited partner redeems or withdraws its investment in an appellant partnership and receives a lesser sum by way of redemption withdrawal proceeds than would have been the case absent the infringement, that partner suffers his own personal loss. So that's again the crux of the dispute between the parties. When a partner leaves, there's then a new and different loss. And if we can just see how it was dealt with in the judgment, so we're in Core Bundle 1 behind tab 10, page 134 of the judgment below. And we see at the top of the page, so if we start perhaps on page 133, I apologise, you see at the bottom of the page the heading, the partnership issue, deals with the point shortly. And then over the page, we see exactly the same point towards the end of that paragraph. If a wrongdoer causes damage to the partnership, the financial interests of the limited partners are also affected. And if a limited partner redeems or withdraws his investment, he thereby crystallises his loss. I don't consider he's disabled in English law from bringing his own claim. So it's precisely the same point, and we say it's wrong for precisely the reasons I've given in relation to companies and trusts, that it is not a new loss, it's the same loss. So, my lords, my lady, drawing some threads together, the banks say, and the judge found, that there is a distinction between current and former investors, in particular that loss caused to a current investor by the bank's infringement becomes a new loss, a separate and distinct, to use the words of Marek's, loss when the investor leaves. We say that the banks have produced no authority whatsoever to support this proposition. Now, below they relied on UCP and Nectris, which is now not good law. And we say that it's wrong in principle for the reasons we've given. And we say our position is supported by the judgments in Primeo, in Young and Murphy, and in Elliott and Hattons. And we also say that the bank's argument gives rise to a very odd result, namely that former investors are placed in a better position than current investors. As the court saw, the Supreme Court in Marek's overturned Giles and Rind, and the effect of that is that a current shareholder cannot bring a personal claim in respect of a diminution in the value of its shareholding or lower distributions, even if the company itself is disabled from bringing a claim. But on the respondent's case, a former shareholder would be able to bring a claim, even though they're further removed from the loss. So we say that that's a distinction which doesn't stand up to scrutiny. We say further that there are certain narrow circumstances in which a derivative claim can be brought in the name of the fund by a current investor. However, where such a claim is brought by a current investor, the proceeds of the claim will be subject to any prior claims, for example, by creditors. So it may never actually make good the current investor's factual loss, yet on the respondent's claim, a former investor will be able to bring a claim without any such limitation at all. And then, as we've seen, in the case of limited partnerships in particular, a derivative claim can only be brought by current limited partners on the forfeit of their limited liability protection. Yet, on the bank's approach and on the judge's approach, the former investor will be able to bring his own claim and maintain his limited liability, contrary to the policy of the legislature in Section 6 of the 1907 Act. So we say that all of this serves to underline why in our submission, English private law draws a clear line. It allocates title to sue to the funds, and it allocates loss to the funds, and not to their investors. And as I've said before, the funds and their investors may agree in the arrangements between them, in the Articles of Association or in the trust or partnership deeds, how the proceeds of an action are to be disposed of. But that is not a matter, that's an internal matter, and it's not a matter in which the defendants have any interest. And if we just go back, before I leave this point, if we could go back to Marex, please. So we're on Authorities 5, and this time I want to go to Lord Hodges' judgment. So Authorities 5, tab 43, page 1312. And we say that this judgment is also illuminating of these issues. So that's page 1312 behind tab 43. And starting at the bottom of the page on paragraph 102, now I'm not going to read this out, and I'm just going to summarise. I don't ask you to read it now. But between paragraphs 102 and 107, Lord Hodge is here explaining why the rule in Prudential is a principal development of company law which should be maintained. And he says that there are advantages to the shareholder in investing in a company. And at 103, a shareholding confers a right of participation in the affairs of the company. But then we see that there are disadvantages as well, and that he says that at paragraph 107. So there are advantages and disadvantages in this legal structure. And then over the page, at page 1314, you see what he concludes about all of this at paragraph 108. So the characteristics of a shareholding as a means of participation in a company's enterprise, which are most directly relevant in the context of this appeal, are the default rule of equality among shareholders and the postponement of the shareholders' entitlement on a winding up to the claims of the company's creditors. Against this background, the law's refusal to recognise the diminution in value of a shareholding or the reduction or loss of a distribution, which is the consequence of the company suffering loss as a result of wrongdoing against it as being separate and distinct from the company's loss, is a principled development of company law. It excludes the possibility of double recovery. It avoids a scramble between shareholders to establish their private claims against a wrongdoer in case the wrongdoer does not have sufficient accessible assets to meet those claims. It thereby upholds the default position of equality among shareholders in their participation in the company's enterprise. Each shareholder's investment follows the fortunes of the company. It maintains the rights of the majority of the shareholders, as the Court of Appeal stated in Prudential, and it preserves the interests of the company's creditors by maintaining the priority of their claims over those of the shareholders in the event of a winding up. And that describes, in our respectful submission, good reasons why the law has this rule. And those reasons would be undermined and circumvented by putting former shareholders who have chosen to sell their shareholding and thereby chosen to give up the right to participate in the company in a much better position. And we say that that's exactly the point that the Victorian Court of Appeal made in the context of trusts in Young and Murphy. So, my lords, my lady, those are the submissions we make about the position under English law. I'm going to now turn to the bank's avoided loss argument, and then I will deal with Article 101.
Can I ask you one
of course.
question? When the company suffers the loss, the fact that some of the shareholders may redeem at a lower NAV than would otherwise be the case, in a sense, means that the company has more assets than it would otherwise have. It's a benefit. Why isn't that a collateral benefit which is raised into alias acta?
We think it is. So I was going to come to that in the context of avoided loss, but we think it is. We think that it is a collateral benefit because it's not caused by, and we'll see that perhaps we can just look at it now, that the central case on which the banks rely in support of their avoided loss case is the Swinson judgment in the Supreme Court. And we say that, first of all, we say that reliance on that authority doesn't really address the current situation.
Are you going to deal with this point in due course?
Yes, quite soon.
I'm just saying that certainly from my point of view, I probably need the run-up to it, as well as the short answer, but please give my lord the short answer.
The short answer is
we're coming back to it, it's absolutely fine. Why don't you do it then?
My lord, I'm grateful, but the short answer is we agree with the point that you've put to me. So avoided loss, can we please turn up the bank supplemental skeleton, which is in Core Bundle 2, tab 22, and it's internal page 8. And their argument is summarised at paragraph 32A. So they say, in short, the respondent's submission is that as a matter of law, the appellants may not claim for losses that they've avoided or passed on, regardless of whether any former investors have rights to claim in respect of such losses. So this is the argument that I'm addressing now. So according to this argument, it doesn't matter if the former shareholders, beneficiaries or limited partners don't have their own claims. The banks say that the funds can only recover in respect of loss they've actually suffered. And they say, as Lord Justice Phillips just put it to me, once the investor's redeemed his interest and has been paid less as a result, that operates to reduce the loss that the funds have actually suffered and may recover because they've paid out less on the redemption. So that's the argument. Now, we say that, first of all, there is no authority at all which supports this proposition. And its basic flaw is that it is inconsistent with and would frustrate the rules of law to which I've already taken you to, which allocate standing to sue and which allocate the losses to the funds rather than the investors. Because in each case, the law regards the loss as being suffered by the fund and accordingly doesn't recognise the factual loss suffered by the investors as separate and distinct. And one of the reasons why the law denies that the investor suffers a separate and independent loss as a result of receiving a lower distribution is because the fund can recover that loss. So it's the other side of the coin point that my lord put to me at the outset. The fund can recover that loss by way of its own claim. Yet on the bank's argument, that same distribution operates to reduce the fund's loss, so they can't recover in respect of that loss. So we say it wholly undermines the rule, and it follows that the law can't regard that factual loss as diminishing the loss recoverable by the fund or suffered by the fund.
But aren't there two very different questions here? One is, have the investors suffered a loss and can they sue for it? And what is potentially a different question, which is whether what is the loss the company has suffered? And it seems to me there may be consequential benefits or mitigations which you do have to take into account. Isn't it a matter of looking at each alleged benefit or mitigation to see whether it's properly to be taken into account as a matter of law?
My lord, yes, there may well be benefits that do have to be taken into account. So we're certainly not, it's not part of our argument to say that can't be the case at all. Plainly, there has to be a factual examination to see whether there is. But the problem with this argument, which is that the benefits that are taken into account are the payment of lower sums to the investors, is that it directly cuts across the fundamental rules of principle. Because what Marex is saying, to put it in a different way, is that loss is not loss of the shareholder, it's loss that the law only recognises as being suffered by the company, and the company must be able to sue and vindicate its rights in full. And as soon as you say, well, that same loss operates in a factual sense to reduce the loss that the company can recover for, you have a situation where the premise or the rationale for the Marex rule is the rule is circumvented or undermined. Because what you're doing is you're saying that the rule in Marex says the company must be able to sue for this loss, and then you're saying, well, exactly the same loss, we recognise that the shareholder can't sue for it, but we're going to take account of it in a factual sense, And the result of that is that the company can't actually sue for that loss. And so it directly undermines this species of avoided loss. We say directly undermines the substantive rules that we've been discussing. So that's, and I took you to Young and Murphy, which earlier, and the submission that was made that if the trustee could recover following the redemption of unit holders, that would result in a windfall to the trust because of lower redemption monies paid to beneficiaries. It's really the same argument that was made in Young and Murphy. They were saying, I mean, here it's called avoided loss, there it was called a windfall. It doesn't really matter, it's the same substantive point. And in that case, the court considered and rejected the very argument being made by the banks now. And they said, well, it's not a windfall. It's no more than the proper restoration of the trust funds, inuring for the benefit of those who happen for the time being to be beneficiaries. And so we say it really is the same point. So we say it's not surprising that there's no authority for this proposition. The fact that avoided loss can't arise on the facts, if the court is with us that investors can't sue, is the necessary consequence of the rules which preclude the investors from suing in the first place. So that's why we say, as a matter of principle, the argument is wrong. It would undermine the substantive rules that I've been discussing. Now, the consequence of the bank's argument, if it were correct, would be that nobody could bring a claim for losses caused by an infringement where the fund, where there's a redemption. So that's the consequence of its argument. It would mean that the investors don't have any standing to sue, but neither do the funds. And we say that that's a profoundly unattractive position, other than to the banks, of course.
Sorry, it's my fault. I think the respondents are simply saying that it doesn't matter if they don't have their own claims. They're not saying that the individual beneficiaries, partners, shareholders would have a claim.
No, that's a fair point, my lady. But they say that this argument arises even if they're wrong on the duty points. In a sense, they don't need this avoided loss argument if there is a right to sue on the part of the investor.
I see. So assume then there's no right to sue. They say it doesn't matter because the loss has still been avoided.
Yes, and we say that, well, then nobody could. The upshot of that is nobody could sue at all. And we also say that there would be huge practical consequences, undesirable practical consequences, if they were right about all of this, because, of course, the argument below required them to show that the investors did have a separate cause of action and could sue. So at least there's some sort of containment of the pass-on. But this argument proceeds on the basis that that's unnecessary. And so in every single case, there would need to be an assessment of the fund's interactions with its investors and former investors since between the time of the claim and the date of judgment in order to analyse what the net effect of all of this was. And so would need to look, for example, at changes in share capital and so on. And we say that that is precisely the type of question that the substantive rules that I've been discussing are there to avoid the court's
and were directly looked at in Young and Murphy, for example.
Exactly.
Have I got the right case?
You've got the right case. You've got the right case, my lady. So that's the court in Young and Murphy went through the undesirable consequences that would ensue.
This is why I have to say my provisional view, not having heard anything from Hoskins yet, is that actually the real issue in the case should be res inter alias acta, because park the reflective loss argument, assuming that you're right about that. The real question here is that the companies, the trusts, etc., do have a benefit, in a sense, a corresponding benefit, in that because of the lowering of the NAV, they have to pay out less to the investors. So they do have a corresponding increment to their assets. And the question is that a benefit for which they should have to give credit against the damages they're claiming?
My lord, they may have a benefit because it would depend on the internal arrangements as the court.
Assuming here that
assuming that they might.
Yes.
But we say a sort of they may or they may not. That depends on the internal arrangements as the Victorian court found. So if the internal arrangements require them to provide some of those proceeds to ex-investors, they won't.
Yes.
And that's why the court said, well, this is really a matter internal to the institution.
And that's why it's racing to alias acta.
And we agree with that. And so the central case on which they rely is Swinson in relation to this point. So can we just pick that up at Authorities 4, tab 38? And they rely on the principle at paragraph 11, so it's 1081, the bottom of page 1081. So the general rule is stated as being that loss which has been avoided is not recoverable as damages. And then over the page to this, there's an exception for collateral payments, res intra alios acta, which the law treats as not making good claimants' loss. Difficult to identify a single principle underlying every case. Critical factor is not the source of the benefit in a third party, but its character. Broadly speaking, collateral benefits are those whose receipt arose independently of the circumstances giving rise to the loss. And of course that's true here, because the circumstances giving rise to the loss are the breaches of competition law and the FX trading. Nothing to do, they haven't given rise to the redemptions, to the withdrawals at all.
And that's the broad principle to be taken in the most recent statement, updated statement on res inter alios acta. That's what you take from it.
Yes.
And then it's fact specific.
And then it's fact specific.
And you say there's no connection.
We say there's no connection.
And you say the respondents say that refer to this paragraph and say there is.
Well, I'm not quite sure what they say about it. They rely on this authority, but they say that they rely on particularly on the bottom of page 1081 in relation to the general rule. But we say that
you say the relevant part of this paragraph is what follows.
Yes, and we say that reliance on this authority really assumes the very point in issue, which is whether the loss can be regarded as having been avoided, where the law deems it to have been suffered by the very party who's alleged to have avoided it.
But as my lord says, assume that for a moment, and I understand exactly. You say there's no for legal. As a matter of legal analysis, there is no correlation between the loss. But even if you're wrong with that,
yes, you
say that you are fairly in square. That the redemption was if there was a benefit to the company partnership. Trust was a benefit whose receipt arose independently of the circumstances which gave rise to the company's loss.
My lady, precisely so, because the benefit to the funds of paying lower redemption monies is wholly collateral because it arises from the rules of the fund. And those rules are completely independent from the relationship from the relationship of funds as customers of the bank and the FX trading, which is what gave rise to the wrong. And we say, moreover, that as Young and Murphy made clear, that the relationship, the rules of the fund, which are what give rise to this benefit, potentially, that's something in which the banks have no concern at all. It's a matter wholly internal to the legal entity. So I think in a nutshell, to summarise our submissions on the avoided loss, we say, first of all, it's misconceived as a matter of principle because if it were right, it would undermine the substantive rules that I've been discussing. Secondly, we say that it would give rise to undesirable consequences. And thirdly, the main authority they rely on doesn't help them because this is, if it's a benefit at all, is a collateral benefit and not linked to the wrong. So those are our submissions on avoided loss. I was going to turn now to Article 101, which is really the argument they advanced below. And now
this is your last chapter.
It's my last. Yes. So the banks argue in a nutshell that the CJU's judgment in the Courage and Crean case establishes that Article 101 confers a right to claim damages on any person who suffers a loss as a result of a breach of EU competition law. And so they accordingly say that investors must have a right to sue under EU law, or EU law confers them with the right to sue. And so they say on that basis, even though English law, as I've shown you, doesn't permit a shareholder, beneficiary or limited partner to sue in respect of damage caused to the fund itself, Article 101 requires a different result. And our response, I'm going to tell you our response in a nutshell and then take you to...
Could I just understand the sequencing of this, English law, EU law?
Yes.
I mean, you've got to deal with things in a certain order. But if the banks are right about this issue, then that's that.
The banks have to the banks have, it's a little complicated, my lord, because the banks have to show not only that they're right about Article 101, but that they're right not as a result of the principle of effectiveness, because supremacy, because the judge correctly found, and that's not contested, that the principle of effectiveness does not survive Brexit. So they have to be right that...
In a certain way.
Yes.
Right. So if they're right in that way, that in a sense is the anterior point, is it not?
My lord, it's a good question. I've debated internally with myself which is the anterior point, because one gets into a rather chicken and egg situation with all of this. I would say that the starting point in all of this is English law, because what's being claimed is it's a claim. My clients are making a claim for breach of statutory duty in English law. And so, yes, it happens that one of the statutes relied on is part of the treaty, but the claim is an English tort law claim. And so the starting point in our submission is that one asks oneself, well, what are the English rules relating to breach of statutory duty?
I didn't want to spend a lot of time on this, and I understand that it can be looked at in different ways, but this was a very large competition law breach in this case. And so the nature of the events are competition law events. So I'm sure that the answer doesn't depend upon where one starts. It's just a question of economy of thinking, that the bank's shortest route home is to succeed on this argument on the right basis.
Yes.
Right. So, but I understand that you say there are different ways in which one might set out the arguments. But in a sense, from their point of view, the shortest route home is through this gate.
My lord, yes. There's a slightly different analysis, I think, on their case as between company law on the one hand and trusts and partnerships on the other. And that's because the rule in prudential applies, and that says even if you've got another cause of action, you can't exercise it. And so they would need to show that there would therefore be a clash on their case between domestic law and European law. And they say, well, because it's all about supremacy, European law wins. Whereas their case in relation to trusts and partnership is a little different. They say that trusts and English law of trusts and partnership can accommodate a separate cause of action if one exists. So you don't get to the clash. So there's a little nuance there, but essentially the position is that their case is that Article 101 requires the court to recognise a cause of action on the part of the investor.
But crucially, neither of you appears to be arguing that the answer is provided by the order in which the questions are asked.
I think that's right.
It's a bit of forensic emphasis, isn't it? The way, I mean, you're, and Mr. Hoskins will, I'm sure, attractively present his side as well, but it's you demonstrate to us that the English law is so clear, gosh, it's really stretching it to make Article 101 do it. Or you take Article 101 first, and everything gets assessed in that light. And the judge took Article 101 first.
He did. And
that was a very important part of his thinking. So he goes Article 101 duty, and then he works his way through the authorities. So,
my lady, that's a fair point, and I accept that. There's just one nuance, as it were, which is that going back to very early days of membership in the EU and cases like Garden Cottage Food, it is clear that when one is relying on EU law directly in the English courts, one is doing it not directly, as it were, but as part of the English tort of breach of statutory duty. And so it may not matter at all, but I would say that analytically one starts with the English tort of breach of statutory duty and asks how English law treats that, and then asks whether or not European law makes a difference. But it may not matter, but I just say that because it's not purely a forensic
that's also a fair point.
Do you accept that Section 2 has to be read consistently with 101?
Can I come back to that? Because that may be quite a complicated question in light of Brexit. The answer used to be definitely yes. Mr. Howell is the world expert on all of these things, so he will, I'm putting him under pressure, but he will tell me the right answer. I don't want to give you an answer that's not accurate. So can I come back to that, my lord?
Maybe one answer to, well, you'll tell me the answer.
So I was just going to say what our answer is in a nutshell, and then take you to the authorities, or to two authorities really. So we say, first of all, we say that the respondents have produced no authority which considers this question. So there's no authority which they've been able to point to, none that we found at European level, which grapples with the question of whether, as a matter of substantive law, Article 101 requires participants in a structure such as a company or a trust to be able to claim damages. So there's no authority grappling specifically with that point and finding and giving a positive answer. And of course, the upshot of this argument, for us it's obviously relevant to companies and trusts and partnerships, but one can imagine that in the other member states there are all sorts of legal entities which have different participants, where domestic rules allocate loss and title to sue as between those participants. And there is no authority at European level dealing with this point.
Well, if my lord is right that the judgment in this case has profound implications for all manner of legal relationships in private law, it appears that we've gone into and come out of the European Union without that particular applicant being upset,
Yes.
at least so far.
My lord, it's a profound irony of the bank's argument in this case, which is that we've been happily applying all of these rules, English law rules. So
Well,
nobody
ignorant of how wrong we were.
quite, and so or we would say, of course, correctly applying those rules. They would say, no doubt, that we've been wrongly doing it. But there isn't any case. Take the interchange litigation. There haven't been any cases where former shareholders of Sainsbury's have said, well, we want part of the action, and that's being considered. It's all of these cases have proceeded on the basis that these English rules apply, and
well, if there
it
were
is
before, there will be now.
depending on what the court rules. My lord, yes, but it is ironic that all of these rules have stood the test of time, and now after Brexit, the banks are saying, well, they've got to yield because of this, because of Article 101. And we've made the point in our skeleton argument. We do not think that you have to come close to this because we think we're right on the substance, but ultimately, for this court, although it wasn't open to the judge below, if you were to take the view that this is the effect of Crean, you don't have to follow it because of the exit arrangements. So we've dealt with that point in our skeleton. In my submission, it's a long way down the order of events in this case because we say we don't get to that. Now, the second point we make is, so the first point is no authority that they can rely on directly grappling with this. The second point we make is that the authority they rely on to seek to establish their point is Courage and Crean, which doesn't consider the issue at all. And we say what Crean does establish is that EU law leaves to national law questions relating to the enforcement of Article 101, subject to the EU law principles of equivalence and effectiveness. And we say that that means that questions of allocation of loss and title to sue in the event that loss is caused to a fund are a matter for English law, subject, as I say, to equivalence and effectiveness, and it's not open to the respondents to rely on the principle of effectiveness, as the judge correctly found, and this is now common ground. And the third point we make is that the banks rely on the words any individual in Korean, as I'll come to show you, in order to establish a right for ex-investors to claim damages. But we say that that proves too much, because if the words any individual were read as a statute, then it must be the case that literally any person who has incurred loss as a matter of fact must be able to sue. And in the present context, that would have to mean current shareholders as well as former shareholders. And it must mean that the participants in a legal entity must be able to sue even if the entity itself can bring proceedings. And we say that that position is wrong, and it's wrong in principle, and it would have highly undesirable consequences. It would simply turn on its head all the law that I've been explaining. And we say it's also directly contradicted by Korean itself, as I'll come on to show you. So I'm going to develop those submissions. Those are our three submissions on the point. And I'm going to, first of all, take the court to the judgment below. Then I'm going to take you to Korean, and finally I'm going to take you to the judgment of the Irish Supreme Court, which does, in fact, directly grapple with the issue and reaches, we respectfully submit, the correct conclusion. So if I may start, please, with the judgment below. So we're in Core Bundle 1, tab 10, page 123. And I've shown you at the bottom of the page, paragraph 57. We don't need to go back to that, so that's the general rule in trusts. And if we can go over the page, please, to page 124, we can see the bank's submission that Article 101 imposed a statutory duty on undertakings which was owed to all persons, and that where a person suffered loss as a result of a cause of action for damages for breach of statutory duty, could be maintained, a cause of action could be maintained by such person, notwithstanding that he may be a beneficiary of a trust. So the point is, the Article 101 point is being dealt with in the section of the judgment on trusts, but it's the same analysis. The judge then relies on this analysis for companies and for partnerships. So that's the submission made. And then you see that reliance was placed by the banks on Courage and Korean. You see that from paragraph 59, and there's then a discussion of that judgment by the judge, and I'm not going to ask you now to read what the judge says about the judgment, because I want to take you to the judgment itself. But you see the judge's conclusion on page 126 at paragraph 61. I accept the submission that all individuals are intended to be protected by Article 101. This is apparent from Para 19, they're nationals, paragraph 23, individuals, paragraph 24, any individual, and paragraph 26, any individual. However, I also accept the submission made by counsel for the claimants that it is a matter for the domestic courts of a member state to lay down the detailed procedural rules governing actions for safeguarding rights which individuals derive directly from community law. And then we see at 62, the judge recording our argument. So he rejects our submission. So our argument was that it's not accurate to say that under EU law the duty is necessarily owed to all individuals, or to put it another way, that anybody that suffered factual loss must have a right to sue for damages. He says, I'm unable to accept that submission. But then he makes 2 points which actually support our argument rather than undermining our argument. So he says, he refers first of all to paragraph 29. This is in the second part of paragraph 62, paragraph 29 of Korean. Paragraph 29 itself refers to the rights which individuals derive directly from EU law, and the existence and importance of those rights is underlined by the EU principles of equivalence and effectiveness, pursuant to which domestic courts are not permitted to provide less favourable rules or render practically impossible or excessively difficult the exercise of the rights conferred by EU law. And so it's a little bit opaque, but he seems to be accepting there that it is a matter of effectiveness, it is a matter for national law subject to the principles of effectiveness and equivalence. And then he says at paragraph 63, I was also referred, that's by us, to the decision of the Court of Justice in Unibet. This was not a competition case, but it also explained the manner in which rights under community law were to be enforced by domestic courts using their own legal remedies, but always subject to the requirement that domestic courts don't undermine those rights. The relevant passages which refer to courage and Korean are set out in paragraphs 36 to 44. I need only quote paragraph 42, which summarises the matter. And if you look at paragraph 42, it says, but whilst it's in principle for national law to determine an individual's standing and legal interest in bringing proceedings, community law nevertheless requires that the national legislation doesn't undermine the right to effective judicial protection. It's for member states to establish a system of legal remedies which ensure respect for that right. And so we say, well, that's a point in our favour. That's why we showed the judge the case. So there the judge is saying, there the Court of Justice is saying, well, questions of standing are for national law, but subject to the principle of effectiveness, subject to effective judicial protection.
Go back to 62.
Yes.
You hived off the end of that paragraph with the reference to equivalence and effectiveness. But the main point, it seems to me, the judge was making as to paragraph 29 of Korean was referring to rights which individuals derive directly from EU law. I mean, the sentence goes on, but he could have stopped there, started again with something else. Isn't that the basis upon which he reached his conclusion?
Well,
and if so, what's your submission about that?
well, maybe, my lord, it might be easier to
Well, it
read
might
that
be at
point
some
by
stage. I
reference to the
didn't
judgment
find,
itself.
speaking myself, your submission about 62 up to answer the point that the judge appeared to be making there.
No, I think that the judge, with respect, I think the judge's reasoning is apparent mainly from paragraph 61. So he's looking at different parts of the judgment, which we'll come to in a moment, saying, well, that refers to any individual and to
Yes,
individual.
is there some argument about the existence or non-existence of rights which individuals derive directly from EU law?
Well, in rights derived directly from EU law simply means rights that are directly effective in national courts. And the question here, the dispute between the parties, is does the fact that in the context of talking about directly effective rights, the judgment in Korean talks about any individuals, does that mean literally any individual that suffered loss has to have a right to claim damages in national courts, which is what the banks, I think, say? Or is it, as we say, that actually the precise rules as to how loss is allocated in this type of case is for national law subject to the principles of effectiveness?
Well, I'm sure you're right that we're going to get the help from looking at Korean as a whole rather than attempting to decide what 8 words taken in isolation mean.
Well, that might be.
Do you want to go there?
Yes, can I just show you before we leave the judgment, just so that you have it in mind, that 72 to 73 on page 128, this is the point about the principle of effectiveness not surviving Brexit. So I just show it to you so you've got it in mind. Again, that's not a point which is disputed. And you see at 73, that inability is not relevant because the English law of trust does allow a beneficiary to sue in his own name in respect of a duty owed to him and which caused him loss. Article 101 has the effect that it creates a duty owed to any individual, which must include a beneficiary. So that's really the crux of the judge's reasoning. So let's go, my lords, my lady, to Korean. So Authorities, Volume 6, tab 55. And the judgment itself starts, because we have the Advocate General's opinion first, so the judgment itself starts on page 1621 at the bottom of the page. And just to briefly explain the facts so that you can see the context in which all of this arose, the claim concerned losses to Mr. Crean, who was a pub landlord, who was the landlord of a pub, yes, and there were losses arising as a result of a beer tie agreement between him and the brewer Courage that were allegedly anti-competitive. And what was at issue in the case was the English ex turpi causa rule, which precluded co-contractors from relying on their own unlawful act to recover damages. And we can see that from page 1623 at paragraph 11. So that's the key issue. And then we see at 14 the question raised by the reference, whether that rule of English law is compatible with, so the question of compatibility with community law of the bar in English law to the defendant's claim. So that's the issue that was referred.
So that was paragraph
14,
Thank
1623. And then, can I just please just skip to the operative part, and then I'm going to come back, but I want to show you what the court concluded first. And we see this at page 1627. So this is the operative part of the judgment, and you see that it has 3 paragraphs. So the first paragraph says a party to a contract liable to restrict or distort competition within the meaning of Article 85, that's the predecessor number to 101, it's the same provision, can rely on the breach of that provision to obtain relief. Article 85 precludes a rule of national law under which a party to such a contract is barred from claiming damages on the sole ground that the claimant is party to that contract. And then you have at 3, however, community law does not preclude a rule of national law barring a party to a contract liable to restrict or distort competition from relying on his own unlawful actions to obtain damages where it's established that that party bears significant responsibility for the distortion of competition. So, pausing there and just thinking about the operative part of the judgment, on its own terms, the court here is not saying that absolutely any individual that suffered loss must have a cause of action in domestic law, because by paragraph 3 of the operative part, it's directly contemplating a position where a party has suffered loss and is prevented from bringing a claim for damages because they bear significant responsibility for the distortion of competition. So that's the first point we made. And the question is, did the court reach the conclusion, or a key question for the court, is did the court reach the conclusion it did? Because although it's for national law to determine questions of standing and title to sue, national rules must be set aside insofar as they make it excessively difficult to bring a claim, which is what we say, or is the position that Article 101, as a matter of substance, requires, in this case, an investor to have a claim? That's really the key question. And if we go back to the reasoning in the judgment, and if we look, please, at page 1624, at the bottom of the page, the banks, and you've seen the judge...
Sorry, I'm just catching up. Give the references again.
Page 1624 at the bottom of the page. So the banks rely on paragraphs 24 to 28, and the judge below placed weight on those paragraphs, and especially paragraph 26. So if we go on to page 1625, the full effectiveness of Article 85, and in particular the practical effect of the prohibition, would be put at risk if it were not open to any individual to claim damages for loss caused to him by a contract or by conduct liable to restrict or distort competition. So
could we just go back a bit?
Of course.
I'm not familiar with this. The question here was not identifying the individual. The reason this came before the court was not to do with identifying the individual who had a title to sue, because there was an individual. The question was whether he was prevented from suing because he'd signed a contract as a tied house tenant.
Yes.
So the court was not, at least to this point in my understanding,
Yes.
the court was not considering the question which we are considering.
My lord, that's precisely right, and that's why I said our first submission is that this case simply doesn't
Well, so
grapple.
you can't. So, I mean, your argument presumably is one can't simply take chunks out of a case that's about one thing and impose them on a case that's about something else.
My lord, exactly, and
And
moreover.
what I'll need to understand is whether, in their run-up to their conclusion, which you're taking us to at the moment, they deal with matters in such a general way that it's obvious that it does apply to our case.
Well, my lord, we say no, and so may I just respond, please, in two ways to what my lord's just put to me. So first of all, we respectfully agree that this is not a case which grapples with the point at issue in these proceedings. It's grappling with a very different point, and there is a key distinction because in this case, in Crean rather, Mr. Crean was really the only person who could recover damages for this loss. It was loss caused to him. Now, that's very different to the present case where, and so what the court was considering in Crean was a situation where a rule of domestic law was barring Mr. Crean's claim because what was argued by Courage in the domestic courts, and this is what gave rise to the reference, what was argued by Courage is, well, you, Mr. Crean, can't ventilate this claim because of the ex terpi causa rule. You were party to this beer tie agreement. So there's a rule of English law which means that you cannot bring your claim. So the point that the court was grappling with in Crean was a position where the rule of English law barred the claim totally in respect of the anti-competitive conduct. Now we're dealing with a completely different situation because in our case, nobody's saying that if the investor can't sue, nobody can ventilate the claim. That's precisely what the funds are trying to do. So the question in our case, in the present case, it is very different. It's where you have a legal entity in which different persons participate. Does EU law require that X part of the entity should be able to sue as well as Y part of the entity? And we say that there's nothing in this authority which establishes that. It simply doesn't grapple with the point. And so
if you put it in context, the references to any individual, certainly on the facts of Crean, are references to an individual, any individual, whether or not they have done something wrong themselves. If you see what I mean. That was what's going on in Crean. So the fact that Mr. Crean had been party to the illegal contract was not allowed to bar him having a claim.
Yes, my lady. So the
Put that very well.
the key point is that the court is saying, yes, that this is a bar to any individual, i.e. Mr. Crean, suing. I think that's the point that my lady's putting to me. And this English law rule is a complete bar to the claim being ventilated. And they're not saying that where
Sorry,
you
to
have,
a claim which otherwise existed.
which otherwise
That's
existed.
the point. So the existence of a right in this
Yes.
sense is assumed. It's not giving a right or creating a duty. It's, in context at least, saying the right that exists cannot be precluded by a domestic rule of law such as ex terpi.
I think that's correct, my lady. Now, what the bank says, well, no, it goes much further. It says that any individual who suffers loss must have a right to sue. And we say, well, you don't read that as a statute because there may be all sorts of, this comes back to the Unibet point, there may be all sorts of reasons why national law confers standing on individual X rather than individual Y in respect of that same loss. And nothing in Crean can be read as disapplying those national rules, and it's really a different point. And the point, so So it's not, as Lord Justice Jackson put to me, it's simply not grappling with the issue where you have a sort of legal entity with different participants, which of those participants can sue. It's a completely different case. But because there is no authority, no doubt, that helps the banks, what they're seeking to do is derive from this authority a proposition that community law that community law requires that any individual not be barred by national law from seeking damages.
Where is the text of 101 in our paper?
I hope we have it in the authorities bundle. Let me tab 50 of the authorities. What's volume 5 of the authorities?
Yes, thank you.
Tab 50.
Okay. Right, I just want to look at this. Right, so the all persons comes from the court rather than from the actual article.
Yes.
Right.
And then if we go back to 1624, we see it at paragraph 23, the court saying that Article 85, as it was then, Article 101, is directly effective and creates rights for the individuals concerned, which national courts must safeguard.
I'm sorry.
1624, the bottom of the page, my lord. I've gone back, sorry.
Yes, well, obviously there are a number of points further up this page which are of a very general nature, and I'm just trying to find out whether there's anything starting in 19 and onwards which gives any flavour of the thinking.
My lord, I don't think there is. If Mr. Hoskins does, no doubt he'll take you to it and I can deal with it in reply.
But under 23...
So 23, I just wanted to take you to, because I think it's a point that my lord picked up, which is the point about direct effect. So Article 101 produces direct effects in relations between individuals and creates rights for the individuals concerned. So direct effect is all about, that's the BRT and Sabam case, which is a very early case, which is all about, there was a debate at some stage about whether Article 101 could be relied on before national courts at all by individuals. So it's saying there that it can. And then you see...
But neither of those cases, or I'm sure we would have been shown them, descend into what they mean by individuals.
No. My lord, that's right, and that's really the key. And we say that they...
Right, so your case about this is that Courage and Korean produces very thin pickings from our point of view.
Very slim pickings, yes. And for three reasons, if I can summarise. One, because it doesn't grapple with the point at issue in this case, or anything like the point at issue. It's a different issue. Secondly, because it's actually, as I'm going to come on to show you, better understood as a case about the principles of effectiveness and equivalence, which leave to national law questions like who has title to sue. And thirdly, because their argument proves too much, because if they're right on any individual point, well then Marex is a case which prevents current shareholders from suing. So they would have to, so that it can't be right that something so profound as to obliterate all of these national rules allocating loss between different constituent elements of a legal entity have to give way because of this authority which presents slim picking. So really those are the three arguments in a nutshell that we make.
Was there any consideration of 101 in Marex?
No, because it wasn't about competition.
No.
My lords, I am actually in the middle of this case, but I'm just looking. I've been reminded that we need a shorthand, a transcriber.
Yes, that's very kind of you to remember. I'm sorry that we didn't do so ourselves. All right, we'll rise for 5 minutes.
If you wish to have a discussion, probably nice to go outside. And if you want to come for a break,
Thank you.
so as you come in, I know they're ready. Yeah, so pretty much just give me a heads up.
Sure, we'll do.
Oh my goodness, you are fully equipped, aren't you?
The line tic tacs. Good stuff.
Nuts and fruit. Oh, you're fruit. Oh, yeah. There are some chocolate bits though, you know. Sorry. I know.
Get these sweets. So I'm quite proud of myself.
Oh yeah, yeah. Well, do you want to give it to me? So? Otherwise, I'm not
Oh,
going to be able to recollect it. Just to read it, just to decipher. Do you want me to type up the one in Webster as well? That was shorter.
Yes.
Brown envelope.
Probably looked even more.
It's just a massive selection.
You have to
of mix. I made a
All right, sorry.
Sorry, I should have taken a picture of that. We've got the technology.
That's the end of it. I'd say getting really excited in mediation.
Yeah, nothing happens in mediation.
No.
Well, yeah, that's why you need the
Slow
release. Slow
process.
Yeah.
There's
I just get bored now. All right.
There's some
I
kind
think
of
it might be art.
weird law as well. I'm not going to be good
That's the point, isn't it?
Yeah.
The amount of time media spends with the other side. 10 times the amount of time they spend with you. No matter what situation, which party you are.
This is all based on your personal experience.
All based on my personal experience, but in all mediations, I don't think that's true. A mediator comes and pops in and spends 10 minutes with you, is that not going to the other side?
God, another.
Oh, really?
Or you mean
Out.
you could tell me the effects is good, isn't it? That's what I'll give it.
Imagine how much Andrew and I love sitting there for an hour and a half just being happy to stay. And another thing. Don't get the accents out. And another thing. Because I do amazing accents. I can basically do the whole JPG course on my own with accents.
We should get you to join one of the schools in that case.
Oh yeah, I can do that. Oh, ouch.
How much time you saw? I mean, that was
Jesus, it's getting warm in here.
Just joking, guys.
Glad I'm wearing a mask here.
Funny, it's true.
Yeah, it is. It was a technological error which actually my driver's license application. I've just then we've got changed it.
Gosh, it looks like it's a particularly important thing.
It is, in a sense. It's my personal life, yeah.
Yeah, that's
No, it's on the computer. It's just, I'm just touching it. Never bothered to.
not too much to think on there every day.
Exactly, that's my idea of a good time. Yeah. Think about it.
Yeah. This is just a
I was going to say. Silence for advice.
Yes.
We were in the judgment on Crean, so if you still have that open, on page 1625, please.
Yes.
And so I was showing you paragraph 26, which is really the high point of the bank's argument. Paragraphs 26 and 28, really. So 26, the full effectiveness of Article 85 would be put at risk if it weren't open to any individual to claim damages for loss caused to him by a contract. And then at 28, there should not therefore be any absolute bar to such an action being brought by a party to a contract which would be held to violate the competition rules. You have my point that this is looking at a very different thing, where the only person that could ventilate the claim was Mr. Crean, as opposed to the type of rule that we're looking at.
And then be encapsulated with reference to 26, that where it says that the article wouldn't be of practical effect if it was not open to any individual to claim damages, that the point that's really being made is it's not open to an individual to claim damages.
Well, I'm not...
And what's the weight that is borne by... I mean, the individual here is an individual who's a contracting party.
Yes.
Is the point that's being made.
Yes. I think that that's right, my lord. we certainly say that you don't read any individual as a statute to mean literally any individual that might. So that's really our point.
No, I'm just trying to identify what the point is, and no doubt
Yes.
it'll,
I think
Mr. Hoskins, as it were, will dispel the point when it's his turn. But at the moment, you might put it as saying that a very considerable amount of weight is being placed on the use of the word any in that paragraph.
that is what we say, my lord. And if one thinks about English statutes, and we make this point in our skeleton argument, and we've included some of these statutes in the bundle, but I'll just make the point briefly without turning it up, that where you have an English claim for breach of statutory duty, it's quite common to have a statute that says any person may do this or any person may do that, but obviously that needs to be read in context, and it doesn't mean that the reflective loss rule is somehow set aside, because you have to say literally any person, including shareholders of a company, for example. So we say that much too much weight is being placed on the words any, and what's being said at 28 is that the rule of English, the rule of English law, the ex terpi causa rule at stake in that case, presented an absolute bar to an action being brought by Mr. Crean, by that person, and so they say there shouldn't be an absolute bar on this individual bringing a claim, being the only individual prevented.
Was it actually decided in that case that it was ex terpi on behalf of Mr. Crean?
No, so
Or was this just a theoretical discussion about what it might
have
been?
My lord, no. So what was decided was that he could sue, and Mr. Crean did sue, and he won. He lost at first instance when it came to the trial. Won in the Court of Appeal and lost in the House of, I can't remember if it's the House of Lords or Supreme Court. I think it was still the House of Lords, because I remember being in the committee room. I was a junior barrister arguing the case, being led by counsel for Mr. Crean.
But I'm only interested to know whether being the other counterparty to a contract, to be in a tied contract as a publican is in fact ex terpi causa. Did anybody ever decide that it was?
No, so the rule was relied on to try and
it
bar
was
the
relied
claim.
on, but is that in fact?
No, so the court found applying the principles in this judgment that Mr. Crean didn't bear significant responsibility, because he was a lowly publican and this was a large brewer that was imposing standard terms.
But it didn't jump out as being particularly disgraceful.
No, I completely agree, my lord, and that is where it ended up, but it did spawn this reference and several court hearings before the
It's
court.
all about something that turned out to be nothing. Yes. All right.
My lord, just going back to paragraph 29, what the court's saying there is that in the absence of community rules governing the matter, it's for the domestic legal system of each member state to designate the courts and tribunals having jurisdiction and to lay down the detailed procedural rules governing actions for safeguarding rights which individuals derive directly from community law, provided that such rules are not less favourable, that's the equivalence principle, or don't render it practically impossible or excessively difficult to exercise the rights, that's the effectiveness principle. And so we do say that so I accept that this judgment is not a model of clarity, but we do say that the way that the court approaches it is to say that this is really, these rules exercising the rights, the exercise of the rights in national court are really a matter for national law, subject to the principles of effectiveness and equivalence. And you see at 30 an example. So they say that in that regard, the court has held that community law doesn't prevent national courts from taking steps to ensure that the protection of rights guaranteed by community law doesn't entail unjust enrichment. Now, that's an interesting example. It's not directly relevant here, but of course what the banks say is that, oh, well, this principle of it being down to national law, that concerns only strictly procedural rules. And indeed, there is a reference to procedural rules in paragraph 29. But by procedural rules, and this is a point we deal with in our skeleton, what the European Court is really looking at are the national rules governing enforcement of the right. And you can see that rules relating to unjust enrichment aren't procedural rules at all, as we'd understand them. They're substantive rules of law.
Nor under 31 significant responsibility for distortion of competition.
No, I think that's also correct. I'm not sure if I'm not sure if it's been designated, if one sees that as a procedural or a substantive rule, but it has a substantive effect. So, and then 31, provided that the principles of equivalence and effectiveness are respected, community law doesn't preclude national law from denying a party who's found to bear significant responsibility for the distortion of competition the right to obtain damages from the other contracting party. Under a principle which is recognised in most of the legal systems of the member states, a litigant shouldn't profit from his own unlawful conduct where it's proven. And so, in other words, the court's directly contemplating that even if a person has suffered loss, national law can deny them the right to obtain damages, subject to compliance with the principles of equivalence and effectiveness. And that's why, going back to the operative part which I showed you, the absolute rule of English law was held to be incompatible with EU law, but a modified version of it was not. So,
How do you square that sentence with paragraph 26?
Well, we say that paragraph 26 can't be read as a statute. So it's not saying any individual that as a matter of fact has suffered loss. What they're looking at is the individual in this case, Mr. Crean, who is the only individual that can recover for this loss. And it's then going on to say that, however, so it lays that down as a starting point, but it then says, however, this is paragraph 29, in principle, those are matters for national law.
I mean, I don't see how you can read 26 in the open-ended way that might be suggested when you've got 31
No.
there in the terms that it's in.
My lady, that's precisely our point. We respectfully say that that's right, because if it were right that paragraph 26 was to be read in that open-ended way, the very conclusion in the case would be wrong, because the conclusion in the case is that there is a category of person who might have suffered loss who national law can prevent from claiming. Now, it may be helpful also to look at the Advocate General's opinion, the reasoning of the Advocate General. So if we look at 1618 earlier in the report, we see at paragraph 45 at the top of the page that it's the second stage. So the first stage in his reasoning, to put this in context, you can see from paragraph 44, he finds that as a matter of EU law, Article 101 doesn't only protect third parties. So there's a question, well, does Article 101 only protect third parties as a matter of substance? And the Advocate General found, no, that's not right. And then he says at 45, the second stage in my reasoning leads me to examine the way in which it falls to national courts to safeguard the right which Article 81 creates for a party to an agreement in certain circumstances. And then you see the reference to direct effect at paragraph 46. And then at 47, in that regard, in actions based on community law, the conditions as to both substance and form laid down by the various national laws may not be less favourable than those relating to similar domestic claims, principle of equivalence, nor, as is the issue here, may they be so framed as to render virtually impossible or excessively difficult the exercise of rights, and that's the principle of effectiveness. And then at 48, how should this be applied in the present case? And we see at 51 that there's no problem with the principle of equivalence. And then at 52, necessary to examine whether there's an effectiveness problem. So he says, we must examine whether the absolute bar to reliance on an action for damages might constitute, within the meaning of the case law cited, the framing of conditions as to both substance and form for the action in question that render virtually impossible or excessively difficult the exercise of rights. And then we see over the page, please, at page 16119, 54, no one disputes that an action for damages is an effective means of protecting the rights of an individual. As the United Kingdom points out, if a party who bore no significant responsibility were debarred from seeking damages, the other party would gain an unjustified advantage. I therefore take the view that the rule of national law in question is such as to render virtually impossible the protection to which a party to an unlawful agreement is entitled under certain conditions. and it must therefore be considered that community law precludes such a rule. So the Advocate General's reasoning is, in a sense, clearer because he's plainly analysing it in terms of effectiveness and equivalence, and he's saying it's for national law to lay these rules down. And so, returning to the submissions I made at the outset and trying to draw together my submissions on this case, we say, first of all, that this authority doesn't grapple with the point at issue in this case, which is whether EU law requires participants in a legal entity, such as a company or a trust or a partnership, to have a separate right of action. Secondly, it doesn't establish that literally any person who suffered loss as a matter of fact must have a claim in damages for breach of EU law of Article 101, because that would be inconsistent with the ruling itself, which recognises that some people might not, and that national law can go some way to excluding such causes of action. And thirdly, we say it supports our submission that EU law leaves questions relating to the enforcement of Article 101 to national courts subject to the principles of equivalence and effectiveness. So that's in a nutshell what we say about Korean, and we say that it simply doesn't bear the weight that the banks seek to place on it. We also say that if they were right that any individual must mean any individual, if they were right that any individual must confer a right of action on a former investor, they must also be right that a right of action is conferred on a current investor. There just simply is no basis in this judgment. They can't chop and change in the words any individual. So either they're right, we say not, and it's any individual, any investor, because any investor that suffered loss, so a current investor who's paid a lower dividend has factually suffered loss. So if they're right on the meaning of Korean, such an investor, a current investor, must have a right of action. Or they're wrong entirely, and it's up to national law to decide where you have a complex legal structure, like a trust or a company, up to national law to determine who sues, subject, of course, to the principles of effectiveness and equivalence. And if we look at what the banks say about this point, so this point about current and former investors, so if you could just turn up their skeleton argument, please, in Core Bundle 1, tab 6.
Are you going to go back to 61 of the judgment below, Mr. Demetrio? I'm just looking at his... So the judge relied... I'm sorry, I know we've moved on from Korean, but he relied on paragraph 19. The words, their nationals, also their nationals.
Yes, my lady.
Paragraph 23, individuals. Please direct. Individuals, any individual, paragraph 24, and then, as you say, any individual, paragraph 26.
My lady, thank you for reminding me. I think that the only one of those I didn't actually go to was paragraph 19.
Yes, so the reference there to nationals.
Yes, and so, and again, I mean, that's in a sense
Subjects of that legal order are not only the member states but also their nationals.
Yes,
paragraph 19 quoted above. So, I mean, effectively, you say that the first sentence of paragraph 61 is really a conclusion that cannot possibly be based upon that decision.
No, exactly. That is what we say, and it's inconsistent with the decision itself because.
Yes, well, yeah, we don't
So.
Need you to tell us all that again. But,
no, I won't.
But I mean, really, my lady has, as it were, anchored your submission
yes.
in the judgment itself.
I'm very grateful for that.
And now you're going to the respondent skeleton.
I am. So I'm going to the respondent skeleton sorry, forgive me, just one moment, let me find it. So I'm on the respondent skeleton, Core Bundle 1, tab 6, page 88. And I'm really looking at what they say in response to my last point, that if any individual...
What paragraph?
At the bottom of the page, paragraph 72. So they're responding here to our point that if they're right on what they seek to draw from Crean, it must equally apply to an existing investor. And then over the page at 89, they say, well, it's not common ground that such arguments couldn't be raised. It might well be that EU law has that impact. However, that issue doesn't arise in the present case. So that's what they say about it. And they then say that the principle of avoided loss doesn't require that some third party has a cause of action. I've dealt with that already. And then if you could also look at their supplementary skeleton, which is in the second core bundle, behind tab 22. This is the final page of their supplementary skeleton argument. So it's internal page 11, behind tab 22, please. And it's paragraph 43. So again, they say, they refer to our submission, where
It's for another day.
They say it's for another day, but my lord, it's not a very satisfactory response, because they are seeking to interpret any individual, and it is important to front up to the consequences of that interpretation. Now, can I just also ask you to look at the footnote 7, because what they say here is interesting. They say, they say that the footnote, the sentence to which the footnote relates, says the question of how EU law would treat such current investors is itself a complex issue which is not directly raised in these proceedings. And they say, for example, EU law may recognise that current shareholders, etc., may bring derivative claims as a means by which they could vindicate any EU law right to compensation. And it's important to think about what that means, because a derivative claim is a claim brought on behalf of the company, not the investor itself. And it may not actually result in any compensation to the investor. But what they're saying here is, well, that's a matter for national law, and the court would have to no doubt examine whether the national rules are sufficient. So we say that the very fact that they recognise that that's a question for national law is inconsistent with their primary submission that these are not matters for national law. Now, the only other authority...
So where do we get that it would be for national law? Doesn't it say...
Well, they say a
EU
derivative
law.
action, which is a derivative action is an action contemplated by national law. So they're saying, well, if a current investor, the EU law may say, well, national law can comply with community law by affording this kind of rights, but that in itself contemplates that national law determines how these rights are enforced in national court. So we say that there's an inconsistency between their footnote and their primary argument.
If 101 provides a claim for individuals, that includes companies.
Yes.
So why doesn't it reinforce that the company must have a claim?
Well, that is a problem which they don't grapple with. So they don't grapple with that problem at all. And as I've said, I think the corollary of their argument, of course, is that insofar as loss, as they call it, has been passed on to an investor, the company can't claim for it. And so we...
That again just comes back to an avoided loss.
Yes.
Because if the company still has a loss, then it must, pursuant to 101, be able to claim for it.
My lord, it must, we say, yes. So, but really standing back from this isn't a case. So Crean is a case in which there's no question of competing claimants. So who does national law say should be able to sue? So that explains the way that the judgment is approached. But it just simply doesn't grapple with the complex question which arises here, which is that national law says it's for the company, for the fund to sue, and so there's no question of Article 101 not being enforced properly. The company can enforce it, And what national law is doing is saying, well, you've got this legal structure with different participants. This is who we designate as the correct person to sue. So it's not saying there's a bar to a claim being brought. It's just designating who has standing to bring the claim.
That's why they're limiting it to former shareholders. There is no room for former shareholders.
But we say, and I'm going to come on to this, that distinction between former and current shareholders simply doesn't hold up. Now, this question, the very question in this case, was grappled with by the Irish Supreme Court. And I'm going to take you to that now, if I may. So it's the judgment in O'Neill and Ryan. So it's Authorities Bundle 6, tab 61. Page 1828. And just pausing here before we look at the judgment, and we don't need to turn it back up, but the judge below thought that the analysis of the rule in Prudential in this case had been overtaken, superseded by Marex. But the court, I'll show the court that the Irish court's reasoning in this case is entirely consistent with Primeo. But the primary interest of the judgment is not that part of the judgment, because we obviously have domestic authorities dealing with that point. It's the treatment of the relationship between the rule in Prudential and EU law that's of interest. And if we could look at the head note, please, to see the facts. So the plaintiff made claims against the last 4 defendants, including Aer Lingus, based on the EU competition rules. And the essence of the complaint was that those defendants, including Aer Lingus, had caused damage to the second defendant, Ryanair, and thereby to the plaintiff, who was a shareholder in Ryanair. But by the time of the appeal, the plaintiff was no longer a shareholder in Ryanair, as I'll come to show you. And then we have the judgment of O'Flaherty J starting at 1829. And you can see, in fact, at the bottom of that page, at the bottom of 1829, why the plaintiff was no longer a shareholder, because he had brought a petition under Section 205 of the Companies Act and an unfair prejudice petition against Ryanair and other shareholders, and those proceedings were compromised, and in return for which he gave up his shares. So by the time it got to the Supreme Court, he was no longer a shareholder. And if we go over the page, please, to 1830, you see that the judge there is explaining the rule in Foss and Harbottle and in Prudential. And then at 1831, so this is a short judgment, the main judgment is given by Blaney J, which I'm going to come on to. But 1831, in the middle of the page, the most fundamental obstacle of all to the plaintiff, in my estimation, is the fact he's now parted with his shares and has no standing whatever. I agree that the rule in Foss and Harbottle can't come into the reckoning. And then I don't believe that the direct applicability of Articles 85 and 86 is affected in any way by the circumstances of this plaintiff. These articles are directly applicable to the suit of a proper plaintiff who has the necessary standing to assert a breach of one or other or both articles. This plaintiff has no such standing. So he deals with the point pretty summarily.
But that's sort of what I was driving at in terms of saying what is meant by any individual. Is it implicit in that phrase?
Yes.
Any individual who has a suit, who has a proper suit, who has the necessary standing to assert a breach of one or other or both articles as a matter of domestic law. Do you see what?
My lady, yes, and we say yes, and that's why we say that this is left to domestic law, subject to the principles of equivalence and effectiveness, and that's we think what the court was saying in Crean, certainly what the Advocate General clearly said in Crean, and what you don't get from reading any individual is a substantive formulation that, read as a statute,
any individual, whether or not they have the necessary standing to assert.
My lady, exactly. So then we move on to the main judgment, and if we go to page 18, 34, please. I'm not going to read these, but I'm just locating for you where the competition allegations are set out. So nothing really turns on the nature of the competition allegations, but they're set out on these pages. And then if we turn, please, to 1836, and at the bottom of the page, there's the sidebar. The judge says that the trial judge concluded that the plaintiff wasn't alleging any direct damage to himself, but rather damage by the reduction in value of his shareholding in Ryanair, by the damage allegedly caused to Ryanair by the alleged wrongful conduct, which is the competition allegations. I'm in complete agreement with this conclusion. And then 1837, over the page, you can see halfway down the page, you can see that halfway down the page you see the submissions that are made. Before that you see that the unfair prejudice petition made, as a result of which the plaintiff is no longer a shareholder in Ryanair and can't claim as such in these proceedings. And then the submissions on behalf of the plaintiff, which are very similar to the submissions made in the present case, were made under two broad heads. So first of all, it was said that the plaintiff's claim came within one of the exceptions to the rule in Foss and Harbottle. And secondly, and this is the point that we're concerned with really here, is that if it didn't, as the plaintiff had rights under directly applicable provisions of community law, he must be entitled to a remedy under national law. So it's exactly the same point that's being made. So you've got the national rule, or the rule which is obviously applicable in Ireland too, so the rule in Prudential and Foss and Harbottle, which is saying that the claim is a claim of the company because it's loss that's suffered by the company. And you've got the argument being made, which is the same as the bank's argument here, which is, well, community law entitles the shareholder to a remedy under national law, by this stage the ex-shareholder. And then if we could turn on, please, to page 1841. So the discussion up to this point is all about the rule in Prudential, and I just pause. I don't want to take you through that because I've made my points on Prudential. I don't need this authority for that, but I just do want to note that the court's analysis of the rule in Prudential is entirely consistent with Primeo. And then 1841, we see that the conclusion that the claim should not be permitted because the loss was lost to the company. And so in the middle of the page, I'm satisfied accordingly that even if the plaintiff was still a shareholder in Ryanair, he would have no cause of action against the last four defendants. A fortiori, he has none since he's no longer even a shareholder. So there, the court is far from saying, well, it's improved in the shareholder's favour now that they're no longer a shareholder. It says the opposite, and that's really because they've now parted company with the company. And then the judge goes on to consider the submissions based on community law. And what's being said is that under community law, the provisions are directly effective, and there's a guarantee of an effective remedy in national law for rights deriving from these provisions.
Where are you reading from?
I'm so sorry, my lord, it's the bottom of the page. So under community law, the provisions of Articles 85 and 86 are directly applicable. And then it's being said that in community law, there's a guarantee, this is the submission, a guarantee of an effective remedy in national law for rights deriving from directly applicable provisions. And then if there's a conflict, if any exceptions to the rule in Foss and Harbottle don't apply, and there's a conflict between national law and community law, there would have to be a reference to resolve this. And the court finds that these submissions are not well-founded. And you see then, a few lines down, what's preventing the plaintiff from having a cause of action is the fact that a shareholder may not sue in respect of alleged damage to his shareholding resulting from damage to the company, which really comes back to my lady's point about the starting point being, well, who has title to sue? Is there any requirement of community law that this clear principle should be disregarded and a cause of action given? In my opinion, there is not. the plaintiff's submissions relied heavily on his having rights under directly applicable provisions of community law. There's no doubt that these provisions are directly applicable and rights under them must be enforced by our court, but the plaintiff has to establish he has such rights, and in my opinion he has not. If there's been a breach of Articles 85 and 86, the party which has suffered damage is Ryanair. Quite clearly that company could bring proceedings claiming damages. And then you see under community law there's no obligation on our courts to create such a remedy. So, and then if we go on to the next page, 1843, the remedy laid down here by national law, and I'm reading from the top of the page, is an action for damages by Ryanair, and that remedy has at all times been available to Ryanair to ensure the observance of Articles 85 and 86. So again, we say by analogy, the action conferred by national law here is on the funds, and that remedy is available. What the plaintiff is seeking is a new remedy, which the national court is under no obligation to provide. And then it said that, that in the middle of the page, it says that a shareholder may be entitled to bring an unfair petition, prejudice petition, and may be entitled to bring a derivative action. And of course, that's the kind of action that may be available to a current shareholder. But as we know from Marex, even if that type of indirect action is not available, the rule still bites. And then we see towards the bottom of the page, it follows, in my opinion, that even if the plaintiff was still a shareholder in Ryanair, community law would not provide him with a cause of action. As he ceased to be a shareholder, it's clear beyond any doubt that he has no right of action against them. And that's because he's given up his rights in the company. So the Irish court regards it as very clear, did grapple with precisely the question at stake here, which is, does Article 101 and the rights it confers require national courts to create a remedy? And it found that it did not. And we say that the analysis of the Irish Supreme Court is correct. And we say it's also right as a matter of principle to find that ex-investors should not be in a better position than current investors for the reasons that I gave previously. Because, as I say, former investors have voluntarily given up their limited rights in the funds and should not get better rights against third parties when they do so. So that's how we say the point is properly analysed. And as I say, that's an authority which does grapple directly with the issue in hand, and we say it does so correctly. And there is no authority there is no other authority in the respondent's favour which grapples directly with the point. And
the logic of the argument would be that not only would shareholders or possibly former shareholders have cause of action and suffer loss, but former shareholders of the shareholders and former shareholders of the shareholders of the shareholders ad infinitum.
My lord, I think that must be right, and so that's why I say that the consequences of the argument are extremely undesirable. And really, that's why, and we saw it in Marex, why domestic law lays down these very clear rules when it comes to companies and trusts and partnerships, and why you see the general rule in trust reflected in the practice direction. Sorry, in the rule of practice. Being that the trustee can sue and the defendant will know that that's it. So a defendant sued by a trustee or a company doesn't have to worry about lots of subsequent claims coming out of the woodwork, nor does the court have to worry about working out exactly what has happened in the interim in terms of relations between the entity and its investors.
I can think of some cases where banks might have been arguing the other side of that.
I know that yes, that irony hasn't been lost on us either.
No.
But my lord,
There's a definite irony in it.
My lord, yes. My lord, just going back to the point you put to me about Section 2 of the Competition Act and whether so we have addressed this. Mr. Howell reminds me in our main skeleton. Can I just show you where it is? So it's in Core Bundle 1. Effectively, we say that the same approach has to be taken, whichever way you go.
It's in the same terms.
Yes, and so Section 60 of the Competition Act has changed. Now Section 60A. But if you look at page 44 behind tab 5 of the first core bundle, and it's paragraph 27, we deal with the point there. And so the point is that Section 60A of the Competition Act says
I'm
that
sorry.
Section 2 has to be...
Give the page reference again.
I
please.
lost the page.
I'm so sorry, it's page 44.
Authorities, page 4.
No, I'm so sorry, my lord. It's core bundle 1. It's our skeleton argument behind tab 5, page 44. And what we say is that Section 60A states that Section 2 of
I'm
the
sorry.
Competition Act.
Got to give us time.
We haven't got I haven't got internal.
It's
page
bundle
numbers.
page 44.
I haven't got page 40.
We've got internal numbers, but not paginated numbers.
Yeah.
Oh, I see. It's page 11. I'm
Thank
so
you.
sorry.
That's all right.
All right,
Paragraph
paragraph.
27.
27.
Can I just ask you
27.
to read paragraph 27 so that you have the point? And just for completeness, if I can just show you page 13 of our skeleton, and footnote 14, that's the intergraph case which is in the bundle, and that's a case in which Mr. Justice Ferris said that he thought the reasoning of the Irish Supreme Court was correct. So we've referred to it in our skeleton. I just point it out.
As far as I can see, that's the only decision that we've got which references the Irish case.
I think that's right. I think Mr. West and Mr. Howe would have found any other authority that
No,
referenced.
but I mean, it doesn't appear to be referenced in any other case apart from the intergraph.
No, and really, it's it's a point that we rely on, which is that there is no authority bold enough. Really, there's been no other case in which these arguments have been run. So there hasn't been a case that we're aware of in which a defendant has sought to disrupt these rather fundamental rules of English law, and certainly there's no direct authority on it at European level.
But can you? I know that my lord will very well understand this, but can I just take the advantage of your explaining that 101 and Section 2 are expressed in terms of utmost generality. These practices are effectively unlawful. But how one goes about combating them is very largely a matter for national courts to work out, having regard to the fact that you can't water it down. You've got to be pointing in the same direction, and that you have to follow interpretations of the European Court as to what it actually means. But all of that, to my mind, comes nowhere near defining exactly who may or may not bring actions, which are, to some degree, policy decisions which have to be taken to make sure that the system works, that the legal system works effectively, that people have remedies where they need them, that if they've decided to buy in to a certain vehicle, that they buy into the remedies that may or may not exist for those. Is there anything more complex than that about the way in which the system works?
No, well, my lord, we say that I think consistently with what you've just put to me, that as a general matter, EU law lays down substantive rights. So the right in question here, well, it's a prohibition in Article 101, but it is then recognised that that confers rights, and so that can be invoked by individuals, including companies, in national courts. And as a general matter, European law leaves to the laws of the member states, to domestic law, the arrangements for enforcement of those rights in national courts. Sometimes European law seeks to harmonise those arrangements, and so we have a directive in the competition sphere which does, to some extent, harmonise how enforcement takes place. So European law is allowed directly to try and harmonise those things. But where it doesn't, we agree with you that as a general proposition, it's for domestic law to determine things like who has standing to sue, how loss is allocated, subject always to the principles of equivalence and effectiveness.
Thank you.
My lords, my lady, unless there's anything further, those are our submissions.
Thank you very much, Mr. Richard. All right, well, Ms. Hoskins, unless it pains you, we'll, I think, have regard to the transcriber's situation. Would you particularly like to spend 10 minutes now, or would you like to start again?
I can see it's been a long day for all of us. I'm slightly concerned that if I don't take the advantage of 10 minutes, we may find we're running out of time tomorrow, because there's an awful lot here in this case.
You've got 10 minutes to, as I remember,
To
Lord
dazzle.
Justice Longmore, as you've no doubt heard him say, to poison our minds. Before,
There's a challenge. Let's remind ourselves why we're here. This is an appeal in respect of a strikeout application. And the strikeout application was brought on the basis of pure questions of law. That's recorded in the judgment at paragraph 40. It follows that for the purposes of this appeal, the pure questions of law should be decided on the basis of the following assumed facts. And I don't think there's any dispute between us as to these facts. First of all, it's to be assumed that the respondents infringed Article 101 TFEU in Section 2 of our Domestic Competition Act. Secondly, it's to be assumed that these infringements caused the funds, the appellants, to suffer loss. And thirdly, and most importantly, it's to be assumed that when an investor redeemed its investment in an appellant fund by reference to its NAV, the fund may have paid and the investor may have received a lower sum by way of redemption proceeds than would have been the case absent the infringement.
that's a may.
Well, because we haven't investigated the facts yet, so we just don't know. But if that is the case, then all these arguments come into play. If at the end of the day that turns out not to be the case for any of the funds, this point goes away. But it's not for today. That's the assumed fact for today.
But picking up on that point, surely you assume the fact must be loss or lower sum paid.
It's another way.
It doesn't make a difference either way.
It doesn't.
These are assumed facts.
That's right.
Okay.
Now, at first instance, the appellants did not raise or argue any issues of causation or remoteness or foreseeability or collateral benefit or any arguments of res inter alios acta. So again, for the purposes of this appeal on a point of law, it has to be assumed the respondents will succeed on those issues at trial. So, for example, collateral benefits, accept what Justice Phillips says, it may be the answer to this case, but it can't be the answer to this appeal because it wasn't argued below. And I think Mr. Mitchell quite fairly accepted that you have to look at it in the factual context.
How can you, forgive me, Miss
No, I wanted to confirm that we didn't argue it below, but that's because it's responsive to the avoided loss point, which also wasn't argued below and which appears in the supplementary skeleton. So that's the context.
But I was just going to say, how can you ignore res inter alios acta in the light of your avoided loss argument?
Because if we're right on the avoided loss argument, then I'm going to submit that you cannot strike out the parts of the pleading which relate solely to avoided loss, and then the correct procedure thereafter, if the appellants want to then argue that it is a collateral benefit and there is res inter alios acta, then they will have to bring forward their argument on that, both legally and factually. But none of that has happened yet. It doesn't matter why. The point is that point is not in this appeal. It may well be an important point for this case, but we haven't reached that stage yet.
If you're arguing a new argument on avoided loss, how can you avoid?
It's not a new argument. Well, it's not a new argument allowed. It's in the voluntary particulars.
Yeah.
Avoided loss is trailed throughout the voluntary particulars. I'll give you the reference. You've seen it. It's voluntary particulars are at core bundle 2, tab 21, at page 794. I hear lots of rustling behind me, so let's go to it. Let's go to it. Core bundle 2, tab 21. Let's begin at paragraph 3, which have already been shown. That's page 789. If you read it, you'll see the distinction is made between avoidance, mitigation, and or pass on. And that triumvirate, avoided loss, mitigation, pass on, appears throughout. So you see it again at paragraph 8 on page 791. You'll see it on page 794 at paragraph 15. So with respect, the pleading that loss has been avoided has been live from when these particulars were served, which was prior to Mr. Justice Teare's judgment.
And this is all, but this is a paragraph that is the subject of the strikeout.
That's right. On a pure point of law. My point is, I'll come to avoided loss, we'll deal with it. My point is that we have not had any, the strikeout is not based on any factual arguments, and we have not had any factual evidence yet in this case about the circumstances that might be relevant to whether there was res inter alios acta in relation to avoided loss. We simply haven't reached that stage in the proceedings.
What facts could be relevant?
Do you want to come to that when I deal with avoided loss,
No.
or would you like to deal with it now? I'm simply making, I'll come to it, and we'll go to Lord Sumption's judgment. I simply make the point now we don't have any facts relevant to that before it. This is a pure point of law, and that's, for good or ill, where we are in this case. Let me start with some basic principles of English law, which I hope will be uncontroversial.
I mean, I'd like to give these my fullest attention. It's 12 minutes past. Do you want to do it in 3 minutes, or do you want to start again tomorrow?
We'll start.
Thank you very much.
Thank you.
All rise.